Hello and welcome to today's webinar. For those of you who are joining us for part 2, welcome again. For those who this is the first webinar you've been able to join, if I briefly introduce myself, my name is Claire-Elaine. I'm one of the property litigation partners at Gunnar Cook. As well as being a solicitor, I am also a business consultant working with companies to help improve their strategy, looking at risk management and the efficiency of their businesses, and I also work as a mediator, helping people find efficient solutions when they're enter into disputes. So that's very much where these webinars are coming from. We're looking at a very high level at a number of issues today that come up during the term of the lease. So if I can just move on then, to do a quick recap of why it's important for us to have a look at the proactive management of a lease during its term, as well as all those things that we thought about last time about when we were actually setting the lease up. What often happens is we find that people complete their lease and then it gets put in the bottom drawer of a filing cabinet, never to see the light of day until an issue arises. Actually, that can cause a lot of problems because by the time the issue has arisen, you've usually limited the options that you have for dealing with it. So what we're trying to do is we're trying to look at ways of anticipating workflow to make it easier to manage, to avoid those peaks and troughs and always feeling like you're firefighting. We're going to try and see if we can anticipate issues or at least minimise the impact so that there's less work and less cost involved in dealing with them. Helping to keep control of that tenancy and keep control of the asset, obviously saving costs, and at the end of the day what that does is it maximises profits. So in our last webinar what we looked at was how could we set up the lease itself to the best benefit. What we're going to be looking at today is what's going to happen during the term of the lease. So we will be covering looking at rent collection and what happens if tenants start getting into arrears. We'll be looking at repairs and decoration, service charge recovery, thinking about some other types of breaches that you may come across, and throughout that we'll also be looking at recovery from guarantors as well as tenants. And then finally we'll finish off by having a look at some third-party rights that might sneak in there, which you may not be aware of. So let's start by having a look at rent collection and arrears. So the first thing that I'm going to repeat is about monitoring. You need to make sure that you have some sort of procedure in place that lets you know that the rent payments are being made on time and by the correct party. If the rental payments start lagging behind, then this should give you a very quick indication that something is going awry with the tenant. And if you act promptly, you can often resolve this. Whereas if you leave the rent arrears to mount up or you keep letting the payments get later and later, this is going to mount up greater problems in the future. The other thing just to keep an eye on is who is making the payments. If payments suddenly start coming in from a different party, then that could suggest again that something is happening with the tenant which you're not aware of. It could be they're in financial difficulties. It could be that there is some sort of change going on with their company structure, or it could indeed be that they've let somebody else into occupation and that you're actually dealing with a different party in your property. So it's worth keeping an eye on it. When you have got missed payments or late payments, you need to make sure that you've got an effective process. Now, what this would look like is obviously, as soon as they've missed a payment, a polite reminder can go out. If you don't get any response to that reminder, the best thing to do is actually to pick up the phone and speak to the tenant or the contact of the tenant to find out what's going on. Quite often you can get a lot of more information from a phone call than you can by badgering them with formal correspondence. So before you start making formal demands, have a think about a quick email reminding them the payment's due and it's been missed, and then try and give them a call. If that doesn't work, then you need to move on relatively promptly to sending out a formal letter and recovering the arrears. Ideally, you don't want to leave these rolling on for months and months at a time, because if you do, the sums then increase substantially and it can be much more difficult to recover them. And often, if there is a problem with the tenant, you're then going to struggle to recover because they may have gone insolvent in the meantime or dissipated their assets. Dealing with guarantors, these do give you some security, but you do have to remember that you need to keep your guarantors in communication throughout the term of the lease. It's great if they've signed up at the beginning, but if things then happen during the course of the term and you don't keep them informed, you may find that the guarantee is void. So, for example, when we're dealing with rent collections and arrears, if these start falling behind, then you need to make sure that you have advised your guarantor using a formal Section 17 notice under landlord and tenant under the Landlord and Tenant Act. Make sure that you have actually advised them within 6 months that a fixed sum is falling due. If you don't send them the notice under the Landlord and Tenant Covenants Act, then you are going to find that you're unable to recover from them. So 6 months may sound like a long time, but actually it gets missed very quickly in a lot of cases. So make sure that you're on the Section 17 notice again as soon as possible. If further sums then fall due, it is possible to update that notice. And there is a formal statutory form that notice has to be in. So if you need to serve one of those notices, then please let us know and we'll be able to give you a copy. If your tenant has then got themselves into significant arrears, then you have got a number of options as to how you can deal with them. The first option is you could change how they pay the rent and allow them to recover in staged payments. So it's absolutely fine to agree with them that the arrears can be paid on a payment schedule, or indeed that they can change from doing quarterly rent to perhaps monthly rent if that's going to help with their cash flow and the payments coming in. The thing to remember here, though, is that your guarantor only guaranteed the terms of the original lease. So if you are going to vary the lease, then you need to make sure that your guarantor is a party to that agreement. Quite often, verbal agreements are reached with tenants with regards to varying the payments under the lease. These are then binding. The tenant then defaults on those agreements. And what happens is people then look to the guarantor, but find because the guarantor was not in agreement with that variation, you cannot enforce against them. So make sure that your guarantors are involved in any agreements concerning the lease to keep them on the hook. The other option you've always got is the deposit, which you're obviously holding. Now, I would caution against using the deposit. The deposit is there to guard against rent arrears and repair work that may need to be done predominantly at the end of the lease. If during the course of the lease you start running down the deposit because you are using it for rent arrears or repairs and so on, then what you may find is that the tenant doesn't top it back up. So come the end of the lease, you may find that you don't have that pot of money available. So ideally, you don't want to be using the deposit funds. You want to be getting the tenant to pay out of their own pocket so that deposit stays there to secure the tenancy. You could issue a debt claim against the tenant. This is a straightforward, usually county court process. You've got a fixed sum that is owed, you get a judgment from the county court, and that can be enforced in the usual way. This can be particularly effective against businesses because obviously if they've got county court judgments against them, then they may have problems with their future borrowing and so on. You need to bear that in mind, the effect on your tenant though. In terms of the impact of serving a claim, it tends to make tenants pay up quite quickly. You do need to make sure, obviously, that you've done your 7-day letter in advance. The other thing, if you find that you've got a company that isn't averse to having county court judgments, CCJs against them, then you may want to consider going down the statutory demand route. What this is a formal notice that advises them that if they're unable to pay their debts, you may consider either winding them up if they're a company or declaring them bankrupt if they're an individual. So for companies that owe over £750, we could serve a formal demand, and for individuals, they've got to owe more than £5,000. Or if you serve the statutory demand, that's obviously a step up. That's looking at their business or indeed their own finances going into disarray. So that's usually, again, something that will have a very abrupt wake-up call. Whether it's then worth following through to wind up the company or bankrupt the individual really depends on their circumstances. You probably need to find out some more information, because otherwise you may find that you're throwing good money after bad. The last option, and it usually is the very final option, is forfeiture. If they've not paid their rent and it looks like there's not going to be any other way of resolving it, then the only option may be to forfeit the lease. And as long as you've got the correct provisions within your lease, you can do this by peaceful re-entry. That's going in, changing the locks. You then need to obviously deal with the tenant's belongings if they're still in there, and obviously we can provide advice on that if you find yourself in that situation. The thing about forfeiture is if it looks like the tenant is in significant financial difficulties and potentially going insolvent, you need to get that timing of the forfeiture right. Because if you leave it too long, you may find that you're then not dealing with the tenant, as if they're going into liquidation and they've become insolvent, you may find that you can have some difficulty in forfeiting the lease because you're going to have to deal with whichever practitioner is dealing with the insolvency. So let's move on then and have a think about repairs and decoration. The first thing to know is who is obliged to do what. It seems fairly simple, but we have a huge amount of disputes that come through the doors every day with respect to repairs and decoration. This is because obviously the landlord wants to get the tenant to either do or pay for as much as possible, whereas the tenant obviously doesn't want to put their hand in their pocket to have to keep redecorating or repairing the landlord's property. So there's an obvious conflict of interest there from day one, and it's something that has to be carefully managed. Now, if you've taken our advice and you've made sure that the provisions are clear and comprehensive when you set out on the lease journey and drafted it, then it's going to mean that this is a lot easier for you to determine. However, sometimes it's not that obvious, and of course there are always things that arise that you're never quite sure which provision is going to fall under. If you're unsure about the obligations under the lease, it's always worth checking who's likely to be responsible and who's likely to have to pay for it. I'll come back to the point again that I raised in the first webinar about regular inspections. Now, if you have got regular visits, and I'm not talking them about every month, I'm talking about regular within reason depending on the length of the lease, but during those inspections you should be able to see the condition of the property. So if there are points of disrepair, note them and raise them with the tenant. If you raise them as you go along, they're usually fairly minor. You can usually deal with the points early on before they escalate, so it's cheaper, quicker and easier for everybody to get them dealt with. The other thing to do during those visits is to ask the tenant if there are any issues that they want to raise, and also to remind them that if there are any problems with the property, that they need to advise the landlord or their agents as soon as possible. By doing that, it can bring things to your attention so they can be dealt with quickly. It also makes it very difficult for tenants who've sat on issues to then come back months later and say, well, this has been an issue for months and months and months and you've never dealt with it, because they've had ample opportunity to tell you but haven't bothered to raise the problem. So this can resolve a lot of issues down the line and save you a lot of cost and a lot of time. In terms of repair, as I said, and I've hinted at here, you need to make sure you act promptly. If you leave disrepair unattended and think, well, we're just going to deal with it at the end of the lease, the disrepair has a habit of getting worse and worse and worse, and the costs escalate. And as the costs escalate and the problem escalates, so too does the dispute, and it makes it much more difficult to resolve. The other thing that you've got to remember is at the end of the lease, you've got a cap on what you can recover. The Section 18 of the Landlord and Tenant Act 1927 says, when you've got dilapidations at the end of the lease, you can only recover the equivalent to the diminution in value of the property caused by those dilapidations. So what that means basically is if the property is in disrepair at the end of the lease, then you need to get a valuation done to show how much the property would be worth in repair as compared to how much it is currently worth without the repairs being done. Inevitably, that diminution in value is always lower than the cost of the repairs that need to be carried out. If you're leaving it to the end of the lease, you will probably find that you cannot recover as a landlord the full cost of the repairs you have to carry out to your property to put it back into good order. So you need to have a think about what you can do during the course of the lease. So the first thing that you can do is you can deal with the Jervis and Harris clause, and this is a self-help remedy that's contained in most commercial leases. What that gives you the option to do is after your inspection, you can write a notice to the tenant advising them that the following issues need to be resolved. If they don't resolve those issues within a reasonable period of time, and usually time limits are set out within the lease, so if they haven't started to do the works and aren't diligently carrying on with them within that time scale, then the landlord can arrange to go in, excuse me, and do the works themselves. Those works are then carried out, and then the cost of those works becomes a debt claim against the tenant. So that can be enforced in the usual way. Tenant owes the money. Again, it can be a county court judgment if it needs to be done. There are a couple of things to think about there. One of them is that obviously tenants would much rather do the works themselves and have the landlords and their workmen coming in and out. The second thing, though, is to make sure that you are being reasonable, because you can only recover for works that are reasonably required under the lease. And you also need to bear in mind that while you will obviously cause some disruption to the tenant, some thought has to be given to try and minimise that, because they have got a right of peaceful enjoyment of the property during the term of the tenancy. It can be a very effective way of dealing with things. You could also consider specific performance. This is where the court orders the tenant to comply with the terms of the lease. This doesn't happen very often, as the court generally feels that if there is a self-help remedy, such as a Jervis and Harris clause in the lease, then specific performance isn't appropriate. So the only times when you really find this used is when there hasn't been a well-drafted lease in place. Ultimately, your final consideration, again, might be forfeiture. If you are considering forfeiting the lease, then you need to make sure that you've looked at Section 146 of the Law of Property Act 1925 and served a formal notice. That notice specifies what the breach is, requires the tenant to remedy the breach within a reasonable amount of time. The court usually considers that repairs are reasonable, so it's not can reasonably be completed, so it's not going to be something that you can generally ask the tenant for compensation for, or that you can suggest in the notice it can't be remedied. It's worth noting that if the lease is for more than 7 years and has more than 3 years to run, it is possible for the tenant to serve a counter notice, which means that you can only get possession then by going through the courts. And they'll only grant forfeiture and possession then if the remedy is needed immediately to prevent substantial diminution in value of the property. It's needed because they have to comply with a legal requirement, or it's in the best interest of the other occupiers of the building. So it can get more complicated trying to go down the forfeiture route when you're dealing with repairs, and it's something that shouldn't be considered lightly. In terms of service charges then, let's move on. Okay, the first thing about service charges is the way to avoid disputes is to have an open dialogue with your tenants. Nothing starts a service charge dispute faster than a bill coming out of the blue for more than the tenant was expecting to pay. So if you have an open dialogue with them, you let them know about the issues, you let them know about the plans in advance, and you explain your thought process about how you're going to be approaching them, you will find that you have much easier time recovering your service charge, and that you're much less likely to enter into any disputes with your tenants. You have to bear in mind when you are planning any works under the landlord's obligations in the lease that there is a conflict there between the obligation to repair and the right of the tenant to have peaceful enjoyment. Obviously, you need to carry out the repairs, but you shouldn't be disrupting the tenant's business any more than necessary. Now, inevitably, especially with some of the more significant repairs, you are going to find that there is some disruption. What you need to do is you need to make sure that you've spoken to the tenants about the options, and that when you take your decision, you document the reasons why you've taken the decision to approach things in a certain way. It may be that you decide to do something which isn't the easiest way to work around the tenant, but reduces the length of time the works are going to take and the cost of the works. There are a number of issues that you can take into account, but the important thing, you need to show somewhere documented that you have taken into account the impact on the tenant and sought to minimise that in the context of everything else. You also need to show that you've been reasonable. You need to make sure that you've got quotes from a few people, that you've made sure that the works that you are doing are only works that really need to be done. And if it comes down to it, that is what the court is going to be looking at as to whether they consider they were reasonably necessary in order to keep the building in repair. It's worth noting that the RACS has got a code of practice on how to deal with service charges. The latest one is the 2014 third edition. This, again, a bit like the lease code, is not binding, but it is taken to be guidance for how you should be approaching the calculation and administration of service charges. It's worth bearing in mind, particularly if you are acting as an agent, as there are a number of cases now which show that agents who are not complying with the code can be found to be negligent for not doing so. In terms of your statements and accounts, you need to make sure that you've got everything in order. You need to make sure that you are getting your statements out at the beginning of the year promptly with sufficient information, and you need to make sure that you've got your accounts done as soon as is practically possible. There is no time limit specifically for you to serve those accounts, but I have found in practice that if they're not served promptly, then there ends up being a lot of uncertainty and confusion between the tenants as to what's being paid and why it's being paid. And also proofs of payments and details with regards to the works, if they are challenged, do tend to get lost. So the sooner that you can get those done, the better. It's worth thinking as well about sinking funds or reserves. These are usually for bigger items such as repairs to the roof, putting new lifts into buildings and so on and so forth. They're actually very useful because what they can avoid is a situation where you're going to have a substantive bill going in front of your tenants, because that's usually what triggers a dispute. If it's been built up into a reserve fund over time and then the money comes out of the reserve fund, there tends to be a lot less upset with tenants as to how that money's being used. A couple of other things for you just to bear in mind is you need to have regard to the length of the lease when you're carrying out service charges. There's a case called Scottish Mutual Assurance and Jardine Public Relations from 1999, which dealt specifically with regards to roof repairs. The lease only had a few months to run, and the landlord decided to replace the roof and then charge the tenant for the full cost. And what the court said was that was unreasonable given the length of the lease had to run, and so what they suggested was that they could only charge for what would be the cost of some patch repairs to the roof, which would cover that period. So if you are going to be doing substantive repairs, you need to have a think about when you do those during the term of the lease. And again, this was reiterated in another case called Floor Daniel Properties and Shortland Investments, where the court reissued this judgment saying that it doesn't matter what the significant repairs are, you have to have regard to the length of the lease. Final point I just wanted to make was regards to mixed use buildings. A lot of people are obviously dealing with commercial properties that have got some residential use either above or in part. If you were dealing with a mixed use building, then the requirements for service charges in respect of residential property are far more stringent than those for commercial property. So you need to make sure that you're adhering to the residential property service charge requirements for the whole of the property. The other thing to bear in mind is that apportionment is particularly challenging in mixed use buildings, so you can't base it simply on the space that each tenant is taking up. The calculations need to be more significant, as it depends much more on what services are being used, and generally the courts will consider the residential tenants are using significantly less than your commercial tenants. In terms of your service charge recovery then, first thing you need to consider is what's your recovery process, and I suggest it looks fairly similar to your rent arrears one. Again, a lot can be achieved by a quiet reminder and a quick phone call to see what the problem is. It might help you nip it in the bud. If not, what you then need to do is consider determination. So if the issue is how much the service charges are, and the tenant is saying that they're unreasonable, then ideally what you should have in your lease is a clause that means that you can refer it to ADR, so to an arbitrator or to an expert for determination. They're going to have specialist knowledge about service charges. They're also going to be quicker and cheaper, and it keeps it private, which means, again, that's something that isn't necessarily going to be broadcast to all of the other tenants, either in that property or in your other properties. You can put into place in the clause that if you can't agree on who that arbitrator or expert is, that the RICS can appoint one for you if needed. If you don't have that option, then the other option is to refer the matter to the court for determination, and they will then consider whether the service charges that you are trying to recover relate to works that have been reasonable and necessary, and that's when it comes back in both cases to all of that paperwork and showing that you've had that consideration as to how you've approached them. If you've had to take the matter to court to get a determination, then it may make sense for you to recover as a debt claim. So you ask for the sum to be determined and a judgment for the court to ensure that you have the money paid back to you by the tenant. If it's gone through an arbitrator, they will give an award as well, which can be enforced through the courts if necessary. With the expert, again, it can be enforced in the same way as a contract, because you will then have a determined sum. If you prefer not to go down the court route, because it can be costly and stressful, and it can also damage further the relationship with the tenant potentially, you could consider the deposit, but for the reasons I mentioned earlier, it's not a good idea to run down your deposit during the course of the tenancy. Again, if you're looking to your guarantor, it's worth letting them know initially that there is a dispute with regards to the service charge, because they will put some pressure probably on the tenant to get it sorted out. But bear in mind, as soon as the sum is determined, you should be thinking about serving your Section 17 notice again to let them know that they are potentially on the hook for that sum. And then finally, again, you can have a think about that statutory demand. So if the service charges for more than $750 for a company or $5,000 for an individual, that's the other option, to look at threatening insolvency. Having a look then at some of the other breaches that you might have to deal with during the course of the tenancy. Parking is something that comes out very, very regularly as something that causes issues in a lot of commercial properties, particularly on estates. Hopefully it's been set out in the lease exactly what parking the tenant has got access to and how they should be using it. There may also be some policies and procedures referred to in the lease, which can change from time to time, so there are different ways of structuring it. The key thing, though, is that ideally you want a policy in place that can be referred to, that is clear and can be enforced. If you've got a tenant who is consistently breaching the parking policy, then what you need to think about is how you want to deal with that. Again, the first approach should be informal, but if they decide that they're not going to pay attention to that, then what you can consider is issuing a Section 146 notice threatening to forfeit the lease. If they then choose to ignore that, then your only option may be to forfeit the lease, as it's very limited as to what else you can actually do to stop them misbehaving. In terms of the parking, this then leads into another issue, and this is causing nuisance, either nuisance to other tenants or nuisance to neighbours. And this can be in a number of different ways. This could be because they're dumping rubbish, it could be noise, vibrations, smell, anything that is causing issues. Now, the thing to remember is that as a landlord, you are liable for any nuisance that is caused by your tenants to either other tenants or to neighbouring properties. So you need to make sure that you're actually doing something promptly if you're advised that there is a nuisance being caused. Again, hopefully this can be dealt with in an informal way, but if not, you may have to resort to a Section 146 notice and the threat of forfeiture. Thinking about unauthorised use of the property. Now, unauthorised use, this again is when the tenant has moved in stating that they were going to use the property for one use, and then when you do your inspection you find out that perhaps they've opened a cafe on the ground floor, or they've decided that they're going to start letting someone sleep in one of the areas of the building or something similar. If this doesn't fit within the current planning regulations that you've got over the property, that could cause you some problems. So you need to think as well when you're doing those regular inspections, are they using the property in the way that you would expect? And again, if they're not, you need to consider taking some action promptly. Unauthorised subletting, again, you need to take action promptly on this, because if you don't take action on any of these points that I've mentioned, there is a potential that you could be considered to have waived those clauses within the lease. So if you've waived those obligations on the tenant by acquiescing to what they're doing, then you're going to have a much more significant difficulty enforcing them down the line. But you need to have a think about doing things promptly. In terms of subletting, you need to find out as much as you can about the basis on which the other party has been let into the property as quickly as possible. One of the things that is a particular concern in commercial property is obviously subtenants obtaining security under the 1954 Act, which could mean that while you can get rid of your tenant out of the property, you're then stuck with a subtenant who perhaps you didn't want to be dealing with. As I said before, I've just put down there again to remind you that if any of these issues are causing a particular problem, then the course of action is to serve formally a Section 146 notice. You cannot go in and just forfeit because the tenant is causing issues. You need to make sure that you've followed the proper procedure, or they will get relief from forfeiture. And when they get relief from forfeiture, you can be ordered to pay them significant compensation for disruption to their business. And moving on then, finally, just a few thoughts on third-party issues. So these are issues that are actually nothing to do with your tenant or how they're using the property. They're just things that tend to arise when property has been let for a significant period of time. And the reason for this is, try as they might, tenants are not as diligent as freeholders when it comes to looking after their property. They may not be aware of exactly where the boundaries should be, of what rights other people have over the property. They may just think that that's the way things have always been, or they may just not be paying attention as much as they could be if it was their own freehold. So you need to be aware, and again, these are things that can be picked up during property visits, of these sorts of things arising. The boundaries and adverse possession. One of the things that happens on a fairly frequent basis is when neighbours realise that a property has been let to a fairly unobservant tenant for a long period of time, they can start encroaching onto that property. It quite often happens when you've got residential properties abutting a commercial property and they've decided that they want to just extend their house or their garden or similar. A new fence or a new wall goes up and it's just a few feet over and then a few feet more. Before you know it, you've got an adverse possession claim, and if you then come to sell your freehold, you may find there's an issue with the boundaries, particularly if it's going to be sold for any kind of redevelopment. This can cause problems. So if you're dealing with a freehold that's unregistered, then they would need to have occupation for 12 years. If it's registered, then after October 2003, they needed to have 10 years. Now, 10 and 12 years does sound like a reasonably long period of time, but when you think about the length of the average commercial tenancy, particularly when they've been renewed, Actually, it's not difficult for a tenanted property to soon have a tenant in there over that period of time. And if they've not been paying attention, it's not that difficult for you to find that adverse possession has taken place. So in order for the adverse possession to take effect, it needs to be uninterrupted, and it needs to be the intention of the person claiming that piece of land to have possessed it. So you can interrupt that by noting down that somebody has started to encroach the boundary, writing to them and raising an objection to them doing so and taking steps against that promptly. That will stop an adverse possession claim. However, if it's been left over the time period and you've done nothing about it, you're going to have some difficulty defending. Easements are the other one that come up on a fairly regular basis. Rights of way. Now, rights of way, if somebody is walking across the property or using it for access, this quite often happens across car parks. So you will end up with people perhaps using the back gate from their property to walk across the car park to a main road and so on. If they are using a right of way in that way, without force, without secrecy, without permission, so the Latin for that you'll hear quite frequently is nec vi, nec clam, nec precario. If they are using the property in that way, then after 20 years, it is the potential that they have got an easement over your property. That again is going to be very difficult to challenge. And again, 20 years happens very frequently, particularly in long-term commercial lets. Even when you've had a number of different tenants in there, if it's not been checked in between, that can cause particular problems. Now, one of the things to bear in mind alongside that is if it's a cut-through that members of the public are using, then they may not need to show that they've got 20 years. So it can happen even sooner. So if you do find that there is anybody cutting across the property, using it for a right of way, it's quite often on foot, sometimes with vehicles as well, then you need to make sure that you've done something about that as quickly as possible. The other thing to consider is rights to light. Now, these may not be obvious initially, but it can be quite restrictive on what you decide to do with your property in future if you decide to redevelop the property in any way. Now, in order for somebody to enjoy a right of light, the right is to have natural daylight through an aperture of their building. They've got to have had that aperture in that position for 20 years. If you need to get rid of somebody who has managed to acquire a right of light over your property, you can either obstruct it or you can serve what's called a light obstruction notice, and if they don't object within 1 year, then they lose their right to light. So if you're coming up to thinking about developing your property, that might be worth doing. If you've got somebody who suddenly seems to have put a number of windows down the side of their property, which could have an impact on your future plans for your site or for your redevelopment of your own property, then it might be worth thinking about putting in a light obstruction notice in any case to stop them getting those 20 years. Other things that the tenants don't look at is local developments. Obviously, it's not their building, so it may be less of a concern. They may be aware because it has an impact on their business, but not necessarily because it's going to have an impact on the value of the freehold itself. So again, it is worth keeping an eye on what's happening in the local area around your buildings. You could maybe schedule searches on a semi-regular basis, or again, just take a look around when you're doing a site visit, see is there anything obvious going on in the local area. You want to keep an eye on those developments for the impact they're going to have. Ideally, if you can catch them at the planning stages, then if they are going to have a significant impact, you can raise objections. Finally, if there are any covenants that you have within the freehold title which should be enforced, perhaps about how people should be using the neighbouring properties, or any permissions that should have been sought from you as the freeholder, you should be checking these again as you do your site inspections to make sure that they have been adhered to, because if you leave those, again, they become more difficult to enforce. The final thing I just wanted to comment on today is looking at your land registry address. Now, quite often when properties are purchased, the address can sometimes either be put in as the property address, or indeed it's the registered address of your company at the time when you acquired the property. If you subsequently move registered address, or there's not an automatic forwarding in place from the property to you, you may not be able to rely on the tenant to always pass things across promptly. So to ensure that you are getting notifications about anything that is going to affect your title promptly, you need to make sure that your address at the land registry is up to date. You can check if it's up to date very quickly. It costs £3 for pulling off a big copy of the title to check what the address is. And if you need to update it, it is free to update. If you need any assistance with that, then please do let me know. So that concludes our webinar for today. If you have got any questions at all, I was very pleased a number of people did take me up on this offer last time, but please do give me an email or drop me a line on the phone. My numbers are, I'll just pop up on the screen in a second, and I'll be very happy to help you. Next part of this webinar series is going to be at 12 o'clock on the 6th of November. And what we will be looking at there is variations to the lease. So we'll be looking at rent reviews, break options, requests to assign licenses for alterations, and dealing with subtenants. So those are my contact details, and I'll look forward to hearing from you. Thank you very much for listening today.